We're frequently asked questions for family law matters for unmarried individuals. And there are a lot of changes in the court's system about how these matters are now handled, and we're going to briefly discuss those issues with you. The first issue that we're aware of is that the filing fees have changed, and instead of these applications, initial applications for custody or child support being free for litigants, now the litigants need to pay $25 in filing fees to actually initiate an application or to modify an existing child support or custody order. The other major change that has happened in this area of the law is that now these applications are on a different format, whereas before the format was you could go to a lawyer and have this lawyer do a very similar application to a divorce matter. Now these applications are on specific court forms with checkoff boxes. That's been a big transition for attorneys to get used to practicing in that way. And Amy, have you had any experience with this?
Absolutely. I remember actually filing an application that was similar to a divorce document, and it was kicked back to me. This was just when the rules changed. So now, even if you have an attorney, they do need to fill out these forms. And because this is the FD docket, sometimes we can actually say that FD stands for form documents. You must use these form documents.
Right. Often litigants will go to the courthouse on their own, they'll go up to the family part unit and they'll complete the paperwork themselves. Even if you fill out these forms on your own, if you still get nervous about appearing on your own as a pro se litigant, you can retain counsel and counsel can represent you at these hearings. One thing we would advise you, if you are planning to do any kind of application like this, make sure that you understand it will be quite a long delay before your matter is heard. These applications are, again, treated differently than they would be if you were getting a divorce because they are treated, as the court would say, in a summary matter, not a 6 to 8 month litigation. They'll be decided in 2.5 months or 3 months, depending on the delays in your county. But it does take a while to get your first hearing, and there is a long delay. So our advice to you would be to file these as soon as you can.
You also might have to go to mediation first, depending on your situation. So if it is a custody issue or a parenting time issue, the judge might send you to mediation first. So again, that's another reason why you should go ahead and file your application or seek advice of counsel as soon as possible.